Strengthen your understanding of governance and policy design. The 12-week graduate course in public policy begins 10th January 2026. Apply by 30th November 2025 to avail a 10% early bird scholarship.
Welcome to All Things Policy, a daily podcast by the Takshashila Institution. We are a bunch of policy nerds based in Bengaluru, and we like bringing fresh perspectives to Indian affairs and Indian perspectives to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hi, and welcome to today's episode of All Things Policy. I'm your host, Adya, and I'm going to be speaking with my colleague, Anwesha, who's done a lot of work on digital governance, tech policy, AI. So just to set some context here, after many, many years of debate following the landmark 2017, I think, ruling on privacy being a fundamental right, India's new digital framework is finally coming together, and the DPDP Act was passed in 2023, but then it was pretty skeletal. This year, the government has come out with the official rules, which are like a how-to for companies, as well as like a gist of what citizens get. And of course, as you look into the details, there's many conflicts and concerns about privacy and rights when you look at the rules, when you're balancing user rights with state security. So we're going to be unpacking that a little bit and understanding what the strengths and weaknesses of the rules are and what they fail to address. So Anwesha, over to you. It would be great if you could set a little bit of context and also tell us about the difference between the Act and the shape that the rules are in today.
Yeah. So thank you, Adya. Thank you for having me. Over the last week, we saw the publishing of the final rules. Earlier this year, we had the draft rules, which were then opened up for public consultation. At that point, there were quite a lot of concerns regarding civil society, user protections, because different from other privacy acts that are there in the world, the Indian DPDPA also has certain provisions wherein the user can also be held liable for not complying with the act. This is quite different from other countries. It's usually focused around user rights and user privacy. But here, if you say have provided incorrect information about yourself, you can be held liable under this act and penalized. So there are some such, little different clauses in this act when compared to, say, the GDPR or the US regulations, etc. That being said, one thing that was quite prominent in the rule draft was that the importance being given to purpose limitations. So essentially collecting data, that's only what's required for a certain purpose. And then, but again, there was some vagueness around what the purpose would be, whether or not data fiduciaries, which is any entity that collects data, whether or not they need to send out an itemized list of exactly what data they need and why they need it, etc. Some of those concerns have been mitigated in the final rules, but again, there have been some other rules that have been changed, and those are now setting the stage for future concerns. Also, just for any sort of data fiduciaries or companies, organizations that do collect data, there is an 18-month runway to implementing the act. So you have 18 months to meet the requirements of the act itself, and the rules are meant to help with that. But again, given it's been about almost 9 years since this act has been in the works, given that now it's finally out, that is a positive move. And we can only expect that further clarity around some of these rules and some of the clauses in the act may be given on behalf of the Ministry of IT. But overall, it's a welcome move. There are some nuances to be explored and some serious concerns that may impact not only user privacy, but also compliance on behalf of organizations. And obviously, there will be a cost of compliance. That's true for any such regulation. And since this is quite necessary to have in a country, obviously, organizations can expect their cost of compliance to go up. So that being said, overall, good move, but there are some things that could have been improved upon. There are some more clarity that's required and some such things.
Okay, cool. Thank you. So my understanding was that this entire act is revolving around this idea of empowered consent or whatever. And this, on the face of it, this itemized list of what data is used sounds pretty great, as well as the fact that you have a right to withdraw consent. But I have a question. There's that rule which seems to sort of just pull the rug out from under that, because it talks about how platforms can retain all personal data, traffic data, and logs for a year, regardless of the withdrawal of consent. How does that play out? That doesn't make sense to me. So.
Yeah, completely fair. And I think that's not making sense to a lot of people, because this earlier was not the case in the initial rules. But now, firstly, the data retention period for non-significant data fiduciaries has been reduced from 3 years to 1 year, which is a great move. But with that, there is a sort of conflict there. So firstly, with consent, like I mentioned previously, that they've now detailed out what purpose limitation might mean, in the sense that these organizations will need to provide an itemized list of what data they're collecting. So that's definitely a welcome move. And you also have the right to withdraw consent. But in contrast with the data retention period takes precedence. So if you have asked for your consent to be withdrawn, and this is before that 1 year period, your data will still be retained for that 1 year period and then be withdrawn. This is just so that it can meet any requirements under the law, say for national security or any such investigation. That's the reason that's been stated, to retain this data even beyond when you've exercised your right to withdraw consent. That is quite a conflict, and again, I think different from what exists in other countries. Also, now the data retention has been, you retain data beyond what is required. So say a data fiduciary has met all of their purposes, requirements, etc. from whatever data, and for data retention, perhaps you only need XYZ data. Say you only need personal data, but now you need to retain the logs as well. You need to retain traffic data as well. So that further broadens the scope of what sort of data is being retained. And so that sort of inverts the principle of data minimization. And this we didn't see in the draft rules. It's a sort of new addition to that specific rule. And yes, this is one of the major concerns regarding consent. And even going beyond that, it's good that we have informed consent right now. But again, in a country as diverse as India, with varying levels of digital literacy, what would that actually mean on the ground? I'm quite certain that beyond perhaps 20-30% of the population, and that's quite broad. I mean, it may not even be that high a number. Beyond 20-30% of the population, they may not even be aware that such a law has come into effect, what that might mean in their day-to-day lives. Even if you look at perhaps smaller businesses, non-big tech companies, how they may comply with the rules and what these specific sections mean for them. There's a lot of things to be done on that front, on particularly awareness. But yeah, so that's sort of the conflict between consent and data retention and then withdrawing consent, which is quite confusing at this point of time. But another welcome move has been that there is a requirement to publish the contact details of the data protection officer of any organization, and that is to be included in all communication related to user rights. So that's again a welcome move.
Okay. Another question I had on the retention of data.
Mm-hmm.
As somebody who's watched one too many sci-fi movies and all of that, considering that the draft rules only suggested keeping logs, but now are going forward and holding all data that platforms don't necessarily have a business purpose for, isn't it just making it easier for hackers to have a bigger, more centralized, attractive target that they can then?
Yeah, you're right on that. And I think hacking and generally cybersecurity has been a big concern in this country. And while we do have regulations and we have certain etc. to take care of those concerns, again, with the size of the country and the comparatively low state capacity, a lot of these data breaches, I mean, given that we are a massive market, we do produce about 20% of the world's data. It's a very easy target for a lot of these cyber attacks, etc. So that is a concern, and the more data you store, the more vulnerable you may be for data breaches. And then again, going on from that, there are rules related to breach notifications, which again, there is some confusion there. Fiduciaries must inform affected users without undue delay, but then is that without undue delay from the time that the organization itself is able to figure out that there's been a data breach, or is it without undue delay from when the data breach has happened? And it's not always easy to figure out when or where a data breach has happened within your system. So again, there's some confusion. We need to look at how well these match with the certain directions. And there's also a requirement of reporting to the Data Protection Board within 72 hours. I believe a lot of organizations will, be concerned about the short timelines, which can be quite hard to comply with, and then following from that, what the penalties may be for non-compliance. So definitely a concern, and these timelines perhaps need to be synchronized across the cybersecurity body and then the Data Protection Board as well.
Okay, so the Data Protection Board is the people who are responsible for enforcing the entire act, right?
Right.
So all of this comes under their oversight. Could you tell me a little bit about the board? What is their plan to handle all the issues that could sort of pop up, considering that India has millions of, actually 8 million plus people who are digitally active? How are they going to deal with that? How is that likely to work?
Yeah. So the Data Protection Board, from what I gather, is, a lot of their role is largely around grievance redressal. So they have, the inquiries are expected to be completed within 6 months, which perhaps is a reasonable amount of time. But we also need to consider that the board itself consists of only 4 people. So there's one chairperson and then there's 3 members. And then so this is the main part of the act that has currently already come into effect. The rest of the act will follow, but the DPB is being selected and will be in effect soon. So the 6-month timeline is quite fair, but again, not sure how it will pan out with a 4-person team. And there's also provision where the board may extend that period in increments of 3 months, given whatever reasons. But that being said, each organization will also have their own data protection officer. So if you have a grievance against a certain organization, you will first approach the data protection officer there. And then if you are to escalate it further, then that's when you go to the DPB. So I think that way the process is quite streamlined, and obviously these contact details, etc., will be made public. So in that sense, perhaps it'll work out well. And it's a good thing that the DPB is being set a year and a half in advance of regulation compliance. But yeah, the lack of state capacity will continue to remain an issue. We'll need to see how they're able to streamline the process further, and whether or not it actually works out in real time. Those are things that I'm not sure if it's been tested out yet, but overall, I think it's good to have them set up early and then have a period of trial and error. Yeah.
Okay, cool. Wow, I googled it and it's not 8 million digitally active people. It is 800 million digitally active people. So the 800 million to 4 ratio is crazy. But
that is true. But again, we need to consider that most of the 800 million may not be aware of the Privacy Act, may not be as equally digitally literate. And also, there needs to be more awareness around what your rights are, what you can approach the DPB for, what you can approach whatever organization you have a grievance against for. So there's a lot of nuances to be unpacked. And given that this is a law to implement what is a fundamental right, there should be a lot more awareness being generated around this act and what it would mean for a lay citizen, basically.
Okay, coming to the people the act is supposed to protect, considering the fact that, we've heard so many concerns about children and social media and the internet, and everybody in the world wants to write about it and talk about it. What does the act say about, say, children's rights and parental consent? Is there anything that the act does there?
Yes, it does. Again, this was one of the points of contention with the draft rules as well. So now the Act requires verifiable consent by the parent if a child is using their platform. However, there are a couple of possible concerns in this section of the rules, which is that firstly, how is the relationship between the parent and the child going to be, how is that link going to be verified? All the rule requires is that the parent provide verifiable identification for themselves. And that will be done as, you must have guessed it, through, digital lockers or through a token. And so that's only for verifiable consent of the parent. But then the link between the parent and child, how that will be established, we're not sure. What if it's a guardian and not a parent? The rules very specifically talks about a parent and doesn't say anything about a guardian. So again, that's something I'm not quite clear about, whether, guardians will be included or if it's only parents. And then obviously having the parents provide their verifiable consent, it again opens up the gates for more data collection, more surveillance in that sense. And the primary sort of concern here is that the rule only applies when a child self-identifies as being a child.
Wait, what?
Yeah, so the child needs to say that I am a child, and then the platform will ask. This is how it is written in the rules, where it's not voluntary consent. But then, if they don't follow, and say for example, there's something untoward happens, and it's found that a parent did not provide their consent for their child using a certain platform, then who will be held liable for this? Because like I mentioned, there are penalties for users as well, and there are obviously there are penalties for fiduciaries. So then who is held liable? And I mean, just in order to not fall into that loop of not complying, will organizations or data fiduciaries, will they then make it mandatory for everyone to verify their age before using the platform?
Wow, okay.
Which is, yeah, then that's just blanket. I mean, to use any platform, you'll have to upload your identity or whatever to prove that you're not below 18 years of age. So that's a big concern there. Again, lacks clarity, and this was also there in the previous set of draft rules. Now I think the only thing that's sort of changed in this part is that the adult or the parent needs to be identifiable adult. So again, I'm not quite sure why that is a specific phrase that's used. I can assume that it's because the parent needs to provide some government identification, but again, it's a little murky over there.
Okay, I kind of see where they're going with that, but I don't understand how the implementation works, which is how I'm
Exactly.
starting to feel about a lot of this. Because it makes sense to me intuitively, but
yes, exactly.
so what happens? Okay, I kind of understand how this is implemented within India, but how about things like cross-border data transfer? How are they going to implement guidelines enforcing things on that?
Right. So obviously, with we've got the AI thing that's been happening for a couple of years now, and we're pretty clear that data plays a massive role in how AI models are trained, what data they're trained on, and then hence what outputs they generate. So primarily talking about generative AI. So data has been significant sort of concern, and when people talk about digital sovereignty or tech sovereignty, one argument that does come up is why doesn't India just keep its data within itself, like data localization? But obviously that's anti-free market. You can't store all of your data within the same country, and if without a good reason to do so. So obviously there are some sensitive sectors such as healthcare and finance which require data localization, but it doesn't make sense to do the same for other industries. That being said, where is cross-border data transfer allowed and where it isn't is something that we're not clear about. There is a provision in the rules which says that there will be countries that are blacklisted by the central government. So those are countries where they won't be able to access Indian data, but it's not clear what the criteria for that would be. And so we can assume that there will be a lack of transparency around who these regulations are going to be enforced against, which countries will not be able to access Indian data, how that might impact geopolitical relations. So again, this lack of clarity on this particular topic has been there since the rules, and if I'm not wrong, since the 2023 Act as well. So that continues to remain unclear, and the final rules as well don't clarify.
Okay, wow, considering the emphasis on informed consent, that's not really working because of, the massive lack of transparency.
Right.
But okay, I also just wanted to close by asking you, okay, for like the average citizen, like, well, not you because you know about this, but let's say me, what would you say the biggest barrier is to exercising these new rights that we've been given? Is it just the awareness of the act itself and the fact that people don't know much about this? It's not something that's being widely circulated, so people aren't aware? Or is it how complex consent forms are? So everyone's just going to end up clicking agree anyway, which brings us back to square one.
Exactly. So it has been argued that this form of informed consent may not work for India as well as it might work for countries in the EU, where it has, I think, worked decently well. But it's not the same case in India at all. The minute you step out of, say, a tier 1 city, it will not work out as well, and this might cause some sort of consent fatigue where you're just randomly accepting consent for everything. So I think we're still not clear on how this sort of itemized list of things might work. And I mean, again, this requires emphasis that set of rules that are as complex as this need a lot more awareness, need a lot more clarity. And obviously, there will be civil society organizations taking that forward, where they do, sessions or go out to organizations and people to talk about these rules, to talk about the act and what that might mean in their day-to-day lives. But some of that needs to also come from the body that is implementing this, which is the Ministry of IT and the Data Protection Board, since it's going to be set up. That being said, awareness is a big concern. But another thing is, if we look beyond, in the same sort of line of thought, if we look beyond big tech companies or even significantly bigger tech companies, how might this sort of, compliance to this act look like for, perhaps say a smaller edtech platform, or say pharmacies, or, such, sort of niche organizations or companies? How might compliance look for them? It's obviously going to be a very different effect for them. Are they clear about how they are to comply with the rules? Those are things that still need to be analyzed. We do have 18 months before it's properly implemented, and you're required to comply only 18 months from now. But within that time, I think that is an area that needs to be studied a lot more, wherein how do non-big companies comply with this, and how might this affect them? There's obviously going to be a cost of compliance, but apart from that, are there other difficulties? Is there more clarity that's required? They have one more thing is that they have clarified what reasonable security safeguards are. So there is a list of measures that companies can follow to protect their data, and if you do follow them, then you're seen to be in compliance. And obviously, if you don't have a data breach, but but yeah, even there, what might be some difficulties that companies face? Are those security safeguards too broad, or do they increase cost of compliance a lot more than what it should be? Those are different areas that need to be looked at. And beyond that, there has obviously been a very significant concern of exemptions for the government from this act.
Wow.
Which it's been there from the act itself, and the draft rules obviously followed the same line of thought, and now the final rules as well. So here again, there's been a small change which should be highlighted, which is, so one is the government and government services, etc., are exempt from this Data Protection Act, which means that they will be able to access personal data given the requirement of national security, public order, etc. Again, definitions are not too clear. It's still vague. It's still broad. And to further sort of incorporate a lack of transparency, the final text does not tie government data requests to any sort of necessity test. So there's no requirement for, say, a judge to sit and look at the facts of the case and then justify, or for the government to justify why they require some such data. As long as there's a national security requirement, you can pretty much go ahead and take whatever data you want. And also, even after the fact, there isn't any such oversight into why certain data was taken. And then to add to that, the current rules also impose obligations where data fiduciaries are prohibited from informing, data principals, which is the users, why they, or whether or not they have been following government rules to obtain any personal data. So again, the users are also not being informed as to whether or not their data is being taken for any sort of investigation or anything required related to national security. So it's like a compounding set of factors which are contributing to this, the risk of government being able to access all your data.
Okay, my takeaway from this is that while the rules have the general population's interest at heart, the implementation, I think there's much to be seen there. And there's also this massive elephant in the room with the risk of government oversight.
Yeah.
I guess to our listeners, I don't know, look up the rules, figure out what your rights are.
Yes.
Whether it's in your individual capacity or whether you run a startup and you're suddenly going to have to start keeping logs. But yeah, that gives you something to read about.
And that being said, a lot of organizations are going to be discussing this. There's going to be a lot of op-eds on this topic as well. I think read between the lines, take a look at the rules. It's written in, frankly, quite a simple fashion. It's not a very long document. I think it's about 20 pages in each language. And same goes for the act. So suggested that you read the act along with the rules, so that it gives you a bit more clarity around what the act aims to achieve and whether or not the rules helps it to achieve the same.
Thank you so much. I learned a lot, and I'm sure our listeners will too.
Thank you, Adya.
If you liked our show, deep dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.